everybody. My name is Vilma Vodanovic. I'm a barrister at Trinity Chambers in Newcastle and Leeds, and I specialise in, amongst other things, landlord and tenant. So this is the second of webinars in our series entitled Landlord and Tenant. And I'm going to talk to you about break clauses in leases and what can go wrong. It's well recognised that strict compliance with the requirements of a break clause is required. Courts have consistently upheld this principle, and it is that which gives rise to the insistence by landlords, quite properly, that there has to be strict compliance, and ultimately that can lead to a lot of litigation. This year will have hit landlords and tenants, particularly both residential and commercial, quite badly, and it won't be surprising to see an increase in litigation, given that the stakes are high for all concerned, hence why this might be a topic of interest to litigators. So the lease itself is the basis on which the parties agree contractual terms, and one of those terms will be the break clause itself, of course. Once exercised, it ends the lease as of the break date and all obligations under it. Ordinarily, what you will see is either a rolling break, so exercised whenever on the giving a certain amount of notice, or a fixed date break, which is exercised at a specific point in time. And problems can arise in relation to both. The process is started by serving a break notice. So if that break notice is served, is that not the end of it? You might ask, what could possibly go wrong? Well, a lot does go wrong. Errors are commonly made, and this is because compliance has to be strictly observed. There are a number of problematic areas. I'll highlight some of them here. We're not going to look at all of them, and I'll look in a little bit more detail at only some of them that I've set out on there. So the content of the notice, obviously, is the first issue. What is the notice going to say? And we'll look at that in a little bit more detail. There could be issues regarding the identity of the parties specified in the notice. And that can be tricky if you've, for example, had a change of landlord from the original landlord. The lease has passed hands, or you've had the tenant company that's changed names. So it's a differently named tenant effectively. So what do you do in those circumstances? And I've given you a reference there to the case of Prudential Assurance Company Limited in Excel, which is a High Court decision. And this is a very good summary of the guidance on how to approach this and a review of the relevant authorities. The other issue that might arise is who is serving the notice. You could have issues over managing agents or solicitors serving the notice instead of the tenant. Is there authority to serve the notice? Is that authority evidence? There might be issues that arise there. On whom has the notice been served? Has an agent of the landlord been served instead of the landlord? And does that agent have authority to accept? Where does the authority come from? Where is it expressed? So these are all questions that might be asked. Then we've got the method of service. You need to be careful with this, obviously. There are specific common law rules, of course, and various ways of effecting service. Lots of problems can arise here. I'm not going to delve into those, but I would say is that the lease, of course, is your starting point. Service might be covered in a different clause in the lease, so not just the break clause that you need to be aware of. And then the timing of the service and the period of notice is another area where things can go wrong, and we will look at that in a little bit more detail. So those are all the technical issues. There might be some more substantive issues that arise when it comes to compliance with certain conditions precedent, which are set out in the break clause itself, such as you have to be up to date with payment of rent, yielding up with vacant possession, or other more substantive conditions such as repairing covenants and such like. And we will look at that last bullet point in a little bit more detail as well. So where to start? Well, it's generally worth saying that the starting point obviously is the break clause itself, because that will tell you what was agreed by the parties, but the rest of the lease may well inform the interpretation of the break clause, so you need to look at the whole of the lease and the other clauses, which will perhaps tell you what the parties intended. If you've dealt with the break clause before, don't assume that any two break clauses are the same or even similar. Of course they are, there will be similarities, but mistakes are often made based on assumptions as to what it is thought the break clause says. So you need to read it very carefully a number of times, and once you've worked out what it says, assume strict compliance is necessary with all the requirements and proceed on that basis. So picking up then on some of those issues and the content of the notice being the first one, before you can get out of a lease, you as the tenant need to communicate the intention to exercise the option to determine. So how you do that is you serve a notice, and obviously you do so in writing. Ordinarily, there's no prescribed form or wording. It's unlike the statutory notices that have to be served on tenants by landlords in the housing context. But there may be prescribed content in the clause itself, which must be expressed in the notice in order to make it valid. So you need to look at those. But what other detail is required though? The intention has to be communicated, and the key principle as to how you do that is that you must communicate it unambiguously. You mustn't leave the recipient in any doubt as to what you're intending to do. But what else should go in there? Well, some case law will tell you that there's no specific requirement to refer to the break clause itself, or indeed the name of the parties. Those cases are quite fact specific. If you are serving a notice, a break notice, then you should assume that all the relevant detail needs to go in, such as the date of the lease, the break date, the names of the parties, the break clause itself, any other clauses that are relevant, and anything else that the clause expressly asks you to do, obviously. And the key to avoiding any issues over ambiguity or error is to follow the lease as closely as possible and refer to it as much as possible in your notice. What if an error has been made, though? Is there any scope for remedying that error? Well, the case of Manor Investment, which is a House of Lords decision from 1997, is authority for the fact that you can remedy certain errors. So this is also the case that tells us that the notice must communicate the intention, but whether that intention has been communicated is to be judged with reference to the reasonable recipient test, which is an objective test. Subjectivity has no real place in determining what was meant, and you have to look at the relevant objective contextual scene. And Manor was a case concerning an inaccuracy in the date which was written on the face of the notice, expressing that the term ends on the 12th of January. The break clause said you have to set out when the term ends. They got that wrong because the term ended, in fact, on the 13th of January. And that was the only error. Everything else had been complied with. So the notice wasn't late. You gave the minimum 6 months notice. And the error was looked at, and it was deemed to be a genuine but immaterial error, which still left the recipient in no doubt as to the content of the notice, and it therefore didn't invalidate it. So the error there was cured. Certain errors, though, can't be cured, and it is those which are considered to be material. So the Court of Appeal decision in Siemens Hearing Instruments and Friends Life concerned a break clause which stated that any notice given by S exercising the right to break must be expressed to be given under the Landlord and Tenant Act 1954, section 24, subsection 2. Well, the notice that they gave did not refer to that section at all. Everything else was fine. There was almost full compliance, but not absolute compliance. So the notice was held to be invalid. And the basis for that decision was that the question was whether the relevant event had occurred, namely full compliance with all the requirements of the break clause. And that had to be answered either yes or no. It couldn't be answered almost. Either a purported exercise of an option satisfied both the formal and substantive provisions of the clause, or it did not. So this wasn't just an error regarding a date or the wrong section being set out in the break notice. It lacked entirely the content that was required by the break clause. So the error could not be cured in this particular case. So moving on then to the timing of the communication of your intention to, or the tenant's intention to exercise the option to determine. When does this need to be done? Well, the break clause should tell you this, but sometimes it can be unclear, and it can fall down to the interpretation of how you calculate the dates, which could be wrong, and that's where very often issues arise. Because the general rule is that strict observance of the time limits is to be enforced, there is normally no basis for equitable relief if you're late. Now, I've highlighted there normally because there is some scope for some leeway in very limited circumstances. So you might have a rather extreme situation where there's accident or misfortune which prevents you from serving on time. And this is based on an 1835 case, so it's rather niche. It's unlikely to arise very often. Or there could be unconscionable conduct on the part of the landlord, which leads the tenant to believe that strict compliance on the issue of time will not be insisted upon. So this is equity coming to the rescue, and it's quite specific and difficult to prove. Or there's been a waiver of requirements for strict compliance with the period or any other aspect of the requirements under the break clause. But if we're talking about waiver, this is something that would have to be clearly communicated by the landlord, either expressly, or the conduct would have to be such that it leads really to no other conclusion. So those are limited circumstances perhaps in which you might be able to get the benefit of equitable relief. But most, if not all, leases will tell you a minimum period of notice is imposed. So for example, if you have a 10-year lease with a break date at 5 years, you might have a notice period of 6 months. And that has to be exercised 6 months before the break date, which, as I said, was at 5 years. So you'd have to serve the notice before the 4.5-year point. But when do you start calculating it from? And there are a lot of variations within the leases as to how this is expressed and therefore calculated, so you need to be aware of this. A number of examples that I can go through. If you're given the break date on the face of the lease, then that is the date you work from. That's a relatively easy starting point. If there is no break date given, then you would, and the lease tells you that you should calculate it from the end of the term, starting with the, you calculate the end of the term, starting with the commencement of the term. Then you look at the date of the commencement of the term rather than the date of the execution of the lease. You might have a stipulation that the period is to be calculated from a certain date. Now, generally that date which is given is excluded and you start from the following date. And you might have a situation where there is no notice period specified, reasonable length must be given then, reasonable length of notice, but that's likely to be very rare. So this then leads me on to a discussion of a case which was heard in July of this year in the High Court. And it was a case relating to ambiguity within a break clause as to the timing of the service. So it wasn't ambiguity within the content of the notice, but really the meaning of the break clause itself. And it's a good example of that insistence by landlords on strict compliance and strict interpretation, but also it shows us how courts approach the interpretation of break clauses. So this was a case relating to a lease of a residential flat. Initially it was for 12 months, then it was extended in an addendum to the lease. The break clause that was inserted at the point of the addendum was this, that the tenant may, for this addendum only, serve notice at one point, being 3 months prior to the anniversary of the first year. So what they meant by this addendum was the extension of the lease, which was for about 2 years. And you can only determine it within the first year of that extension. But the key issue was with the use of the words only serve notice at one point. The landlord said this was the 24-hour period which fell on the start of the 3 months prior to the end of the first year of that addendum. And notice was actually served about 4.5 months before. So the landlord argued that this was premature notice and therefore invalid. The county court judge agreed with the landlord and the tenant appealed to the High Court and the High Court allowed the appeal. The key points that the High Court made in allowing the appeal were that its decision was based on looking at the commercial reason for the imposition of such a strict term, in that there wasn't any, not in this residential context certainly. 24 hours being allowed only for the service of notice was not unheard of, but it was a rare a rare term to be imposed in a lease. And is that really what the parties intended? So looking at the whole of the lease and looking particularly at the reason for signing the addendum to the lease, which was to change the break clause from a rolling break clause to a fixed date break clause and to give a little longer to the tenant to stay in the property, those reasons really didn't suggest that there was that intention to be that strict. So in this particular context, it wasn't necessary to interpret the lease so strictly, and that certainly hadn't been intended by the parties. If that had been intended, the court said that it was expected to see something more, something clearer in the wording so that it could be interpreted in that way. So we're then going to move on to look at the conditions precedent. So it's those conditions which need to be satisfied before you can even start to exercise or consider exercising the break option. So the payment of rent is one of the most common conditions precedent that you're going to get. So not just rent, but other charges as well due under the lease, such as interest, VAT, service charges, insurances, etc. What you need to look at is what are the actual words of the clause? What's the condition as to when payment for these is meant to have taken place or how regularly? So you might get a clause which says you should duly pay the rent. So if you're not punctual with paying the rent as a tenant, but you pay the rent before the break date, then you have complied as a tenant. What about pay rent duly and punctually? Well, the landlord has to expect that you've been regular in your payments there. So if the tenant hasn't been paying rent on time, even a little bit late, then the tenant may well have forfeited the right to exercise the option to determine. And you might also see references to regular payments. Now, regular doesn't necessarily mean punctual as well. So there might not need to be absolutely strict compliance here. You might be regularly late in paying, but you're still regular. So as long as the amounts are paid by the date of the break date, arguably you have, as a tenant, complied. Payment of rent in full before the break date can cause certain problems if tenants assume that they can apportion payments. So, for example, if the lease specifies that the rent is to be paid in full for the rent period, which might be 3 months, but the break date falls somewhere at 1.5 months during that rental period, the tenant should not be able to apportion the rent and only pay 1.5 months rent, unless, of course, the lease allows for that. But more often than not, it doesn't. So as a tenant, you would have to pay the rent in full. And there is then no requirement on the landlord to repay the rent after the break date. This can't be implied into the lease. If it's expressly stated in the lease, fine, but it certainly can't be implied into it, which was the subject of the Supreme Court decision in Marks and Spencer's from 2015, and the reference is there for you. Now, in the current climate that we find ourselves in, there may well have been numerous rent or other charges, concessions or negotiations over payment during lockdown. And what happens then? Well, the concession communications should really address the effect of the reduced rent on any break clause. So going forward, if that happens, that is something that legal advisors can think about. If it hasn't been referred to specifically within the negotiations and an issue arises, then what would need to be looked at is the intention of the parties. So you might look at the rest of the lease to see what it says about any leeway being afforded to the tenant generally in relation to rent or other charges. Or you might look at the correspondence regarding the concessions as to whether something can be gleaned from that more generally. If there's no clear written concession, but negotiations were underway or there was a dispute over payment, then the chances are that the tenant might have to pay in full before exercising the option to determine. So if there's no conclusive evidence to say that there's been a concession or there's been a reduction in rent, then the tenant will have to assume that it has to pay in full. So the second most common condition precedent in leases is that of vacant possession. And what does it mean? Well, it means what it says effectively. It's a relatively simple concept, as was stated in NYK Logistics, a Court of Appeal case. There it was said that the concept of vacant possession is not complicated. And what does it mean? It means that the property has to be empty of people, that the purchaser is able to assume and enjoy immediate and exclusive possession, occupation and control of it. And it must also be empty of chattels, although the obligation in this respect is likely only to be breached if any chattels left in the property substantially prevent or interfere with the enjoyment of the right of possession of a substantial part of the property. So a filing cabinet in the basement might not be an issue, but lots of items being stored in the main part of the premises by the tenant will of course be an issue and may well result in a finding that the property has not been given up with vacant possession. Now, I've given you there a reference to a county court decision, which is a good example of a tenant leaving a lot of items in the property and therefore not yielding up with vacant possession, which meant that they couldn't exercise the break clause. Now, moving on to those covenants which require that there is compliance with the repairing covenant, the decorating covenant, or the reinstatement covenant. What about those? Well, a number of things to say about that. Firstly, spent breaches don't count. If the tenant has been in breach before, but the breach has been remedied, then that's fine. The landlord can't demand that everything is looked at from the past. It is only current breaches at the time of the break date that count. What about minor breaches, trivial breaches? They do matter if compliance is meant to be absolute, and then they will count. There's well-established case law on trivial breaches. There's a 1966 West Country Cleaners case which concerned an option to renew a lease. It's still relevant to options to determine, but that option to renew couldn't be exercised because the tenant failed to keep the premises painted every 3 years. Now, you might think that's trivial, but it was held to be relevant. So assume absolute compliance with all of these covenants, unless the lease specifies that they are to be complied with to a material or substantial extent rather than absolute. And you can imagine with material or substantial, or even indeed reasonable compliance, there is going to be room for interpretation and there's going to be scope for disagreement on this issue. So what is in fact meant by material? Well, it's not meant to mean the same as absolute. With absolute, any breach precludes the exercise of a break option. Material is meant to move away from absolute. And in Fitzroy House, which was a Court of Appeal decision back in 2006, they looked at how to approach the meaning of this. And the question of what is a material breach is not assessed by reference to what is reasonably fair to both the landlord and the tenant. Materiality is assessed according to whether the breach of covenant affects the ability of the landlord to re-let or sell the property without delay or additional expenditure. So business efficacy was key here, not overall fairness. It's not a question of being able to say that previous conduct or any issues that arose between the parties are relevant. It is simply looking at whether the property can be re-let or sold without delay or additional expenditure. So substantial and material were deemed to be interchangeable terms in Fitzroy House. But what about reasonable compliance? So the Court of Appeal in Fitzroy House did look at reasonable compliance and stated that it's not the same as material or substantial. It is a different test, or there is a different test to be adopted, but they didn't say what that test was. So considering what it might mean is that it could well be interpreted with reference to the general state of the premises, perhaps, the location, the business function, or any other functional purpose. And the conduct of the parties may also be taken into account under this particular heading. Not necessarily overall conduct in the parties' dealings with each other over the years, but the conduct in seeking to achieve compliance with the relevant covenants and the steps that may well be relevant, steps taken rather that may well be relevant here in terms of how far they got or should have got given their efforts. So those kinds of things may well inform that particular test when it comes to looking at reasonable compliance. So again, looking at the last 12 months or so, and in particular the first lockdown in the early part of 2020 with its own difficulties in terms of getting workmen or contractors in so as to comply with the repairing or the decorating or the reinstatement covenants. Is there any scope for arguing that the tenant couldn't comply during that period or had difficulties complying? Well, if absolute compliance is required under the lease, then the only way to argue this may well be to say that it was impossible to comply as a result of the restrictions that were in place during lockdown. But this is only going to be limited, as I say, to those first or few months of 2020 when we had national lockdown, during which nothing could happen, if of course the facts lend themselves to that. But you'd need good evidence of this, of the impossibility of complying. So some interesting arguments might be raised here, might be thrown up as a result of that. And these difficulties in complying during lockdown are probably more likely to be relevant to the material, substantial or reasonable compliance. But again, will depend on the facts and the evidence that you've got. So this brings me to the end of my seminar. I hope you've enjoyed it and found the discussion of the topic useful. It's a difficult area. There are lots more issues that I haven't discussed. There's lots of room for error, misinterpretation. There can be huge consequences. So legal advice in the early stages could be extremely helpful. So do get in touch with the property team in Chambers, and thank you for listening.